court is calling 2023 CR 5148, State of Texas versus James Ray Hernandez. Can I have parties announced for the record for the state?
Travis Banks for the state of Texas.
Defense.
Afternoon for defense.
Are you James Ray Hernandez?
Yes, Your Honor.
Counsel, have you received all the discovery and did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Mr. Hernandez, I'm showing you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Next, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
State, are you proceeding on the indictment as presented
Yes, Your Honor.
with the enhancement allegation?
Oh, sorry, Your Honor. We're waiving the repeater enhancement and proceeding only on the indictment.
Any objection?
No, Judge.
The air in the courtroom is tense, every word measured, every response carrying weight. James Ray Hernandez stands before the judge, his future hanging in the balance. Legal formalities unfold like steps in a dance he cannot escape. Applications, indictments, allegations. Each yes he utters is not just compliance, but a step deeper into a process that will decide his fate. The stage is set, but this is only the beginning.
Mr. Hernandez, I'm showing you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with aggravated assault with a deadly weapon? That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
The charges are spoken aloud, aggravated assault with a deadly weapon. The room tightens around those words. The judge lays out the penalties: years behind bars, thousands in fines, a life forever changed. Hernandez answers calmly, but beneath the surface, the reality of what he's surrendering begins to settle in. Rights given up, defenses set aside, and a deal that the court does not have to honor. The gavel hasn't fallen yet, but the sound of it already echoes in his mind.
Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Hernandez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that document with your attorney? Did you understand it?
Yes, Your Honor.
With each question, the judge strips away the last layers of defense. Hernandez admits he understands the risks, that one wrong step during deferred adjudication could land him in prison for 2 decades. His attorney affirms his competence, his sanity. No threats, no promises beyond the plea. Each yes is a surrender, and yet it is also a choice. Now the plea bargain lies before him, signed, sealed, and ready to carry him into a future, still shrouded in uncertainty.
According to the plea, there's a $500 fine to be probated. State recommends deferred adjudication. They're taking in consideration 2023 CR 5149. There's an affirmative finding of family violence. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, Your Honor.
Did you understand with the affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, Your Honor.
Did you understand that to be the entirety of your plea bargain agreement?
Yes, Your Honor.
Defense? Is
Yes,
that the
Judge.
plea? State?
Yes, Your Honor.
And also there's an anger management course. State, is that the plea?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? And did you sign it in both places?
Yes, Your Honor.
The terms are revealed: a fine, probation, and the label of family violence that will follow him for life. No weapons, no custody, no return to the way things were. An anger management course is added to the weight he will carry. With each "yes, sir," Hernandez agrees not just to punishment, but to the reshaping of his very identity. The deal is in motion, but what remains unsaid may matter most.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Judge.
Next, I'm showing you outside the plea bargaining agreement. State is requesting that your community supervision be for a term of 6 years. There be the DDRF, 80 hours community service restitution, NIC evaluation, no contact with Joe Ray Hernandez and Rosalinda Hernandez. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
Yes, Your Honor. State offer State's Exhibit 1 and its attachments.
Any objection?
No, Judge.
A deeper surrender now, the right to appeal, gone. Only narrow exceptions remain, locked behind strict conditions. The state pushes for 6 years of supervision, hours of community service, restitution, and strict no-contact orders. Hernandez stands silent, the gravity of no contest settling around him. The state's evidence moves forward, and with it, the case hurdles towards sentencing. The decision is no longer about guilt, but about the shape of the life that will follow.
State, have you talked to the complainant?
Yes, Your Honor. The state has spoken with the complainant and they did ask the state to push for drug treatment for the defendant. And one other thing I want to mention about the repeater enhancement that the state waived. As far as the state can tell, that is not a case that's in his criminal history. I'm not sure how it made its way into the indictment, but the reason, a big reason it's being waived is because it's not part of the scope.
All right, thank you. All right, I'm going to show you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
The state speaks of the complainant's wishes of drug treatment in a strange twist, an enhancement allegation that may never have belonged in the case at all. Hernandez listens, the legal gears grinding forward. Another waiver, another document, another list of rights abandoned. The choices are narrowing, and soon there will be none left to make.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. Court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
Yes, Judge.
All right. This is what the court will do. Well, let me ask you this first. Do you have children?
Yes, ma'am.
What are their ages?
13, 7, 5, and 4.
The trial that never was. No witnesses will take the stand. No cross-examination will unfold. The evidence is reduced to paper and signatures, cold, silent proof. The court accepts it, finds it enough, and holds back the final judgment in favor of deferred adjudication. But before the sentence is set, the judge asks a simple question. Do you have children? The answer opens a door to a different, more human side of the case, and a past that cannot be ignored.
13, 7, 5, and 4?
Yes, ma'am.
And do they live with their mother? Who are they living
My
with?
first 3, their mother passed away. They live with my ex-mother-in-law, and then my 4th lives with her mother.
Okay. All right. Have you ever had any mental health diagnosis?
Yes, ma'am, I have. I've had about 6 in the last 4 years
And what is the diagnosis?
that I have no problems, I guess. I've been to Laurel Ridge, I say behavioral. I actually had one for my last charge of discharge of a firearm from 2020, which was the most recent, and they dismissed that case in March of this year.
It's my understanding that's the only
Yeah.
prior charge he has. Was the
All
drug.
right, so does he suffer from mental illness or not?
Not that I'm aware of. My understanding, the state wanted to have him evaluated.
All right, so what happened this day? Was that drug induced? Were you using drugs that day?
No, ma'am, it was not.
4 children, 2 different homes, 1 mother gone. The questions shift to mental health, diagnoses, hospital stays, moments from the past that blur into the present. A dismissed firearm charge, behavioral evaluations, and the shadow of untreated struggles. The courtroom is no longer just about law, but about the human fragility beneath it. And yet, Hernandez denies drug use that day, holding firm to his own version of events.
So you're telling me that his family think there's some drug issues or mental health issues?
In our communication with his mother, she does believe that there's some drug issues and that he would benefit from drug treatment.
He did attend Laurel Ridge. That was for an inpatient treatment. There was history. There has been a history of drug usage. He went through CPS as well.
Oh, and lifetime recovery outpatient, Your Honor.
Okay. And what drugs were you using at that
Just
time?
methamphetamine.
All right. This is what the court is going to do. It's a $500 fine to be probated, 6 years deferred adjudication, taking consideration 2023 CR 5149, affirmative finding of family violence. There's to be no contact with Joe Ray Hernandez or Rosalinda Hernandez. Anger management. There's to be no unsupervised contact.
The prosecution paints a different picture, whispers of drug abuse, treatment programs, CPS involvement, a history that refuses to stay buried. Now the court's decision comes fast and sharp. A fine, 6 years deferred, no contact orders, anger management, and no unsupervised time with minors. The list of restrictions grows, each one a chain on. His future.
With minors, there's to be a TAP evaluation, MIC evaluation, DDRF evaluation, and that's to take place in custody and follow all recommendations. And there is to be proof of employment. Are you receiving any type of SSI?
No, ma'am.
Proof of employment within 45 days of release. No employment as a home healthcare provider or with minors. Regular reporting by Zoom or in person. The UA hotline until further notice.
More conditions, more control. Evaluations for treatment, proof of employment, bans on working near children. Probation will be strict, reporting in person or by video, submitting to testing, living under constant watch. Every detail of his life will now be tracked, measured, and judged. Freedom, but not truly free.
And field visits 1 time per month for 4 months and then as needed. If he gets a case manager early on, then probation, you can stop with the field visits. Probation, is there anything else just 1 second. We're going to do 80 hours of community service restitution and parenting classes. Once he completes those, the community service restitution will be deemed satisfied. Probation, is there anything else he needs? Is there anything else you need from the court?
No, ma'am.
All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney?
Community service, restitution, parenting classes, more steps in a process that promises rehabilitation but demands total compliance. The court moves to the final document, the trial court certification of his rights. Hernandez reviews it, signs it. The end is near, but not without one last reminder of what this agreement truly means.
Did you understand it?
Yes, Your Honor.
And did you sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, Mr. Hernandez, in this court, in order to be successful on probation, communication is key. If there's an issue, let your probation officer know about it. If you feel that the probation officer is not addressing that, you can always come to court. You understand?
Yes, Your Honor.
All right, good luck to you.
Thank you,
Thank you,
ma'am.
Judge.
You have a good-
The final words are spoken, sealing the deal. No right to appeal. No weapons. No room for missteps. The judge warns him. Success on probation will depend on communication, on honesty, on facing problems before they spiral. Hernandez says he understands. The case is over, but the real test has just begun. The gavel falls, and the story leaves us with one truth. Justice does not end in the courtroom. It follows you home.